appeal in the matter of Gardiner and Hertsmere Borough Council and another.
Yes, Ms. Shaker.
My Lord, I appear on behalf of the appellant in this matter, Mr. Gardiner. My learned friend, Ms. Lambert, appears on behalf of the first respondent, Hertsmere Borough Council, and my learned friend, Mr. Honey, Queen's Counsel, appears together with his junior, Mr. Defer, on behalf of the Secretary of State, the second respondent.
Yes.
My Lord.
We have read the papers, so you can assume that. We're also familiar with the authorities which are cited, and we've made ourselves familiar with the legislative provisions.
I'm grateful, my Lord. I just wanted to deal with one housekeeping matter.
Yes.
I sent through 3 documents. I don't know if you received those.
Yes, yes. I say we, I certainly did, and I'd assume my colleagues did.
I'm grateful. No, I don't know if you want any assistance where I thought they might fit into the bundle.
Yes, it would be helpful, I think, just to do that first.
I'm grateful. So, my Lord, in terms of the consultation document, which is the next few pages on from what's already in the bundle, that's tab 17 of the supplementary bundle. So directly behind page 129.
Yeah, I didn't get tabs, but it doesn't matter, but I didn't actually get tabs. So you want it in at after 129?
129, so between that and page 130.
Okay. I'll just write on the first page 129A.
Yes.
And then I won't take the time of writing all the other numbers down, but that will be a guide for later on. Yes?
I'm grateful. Well, the other document relates to the legislation that was inadvertently missed off. That's the social housing legislation.
Yeah.
That ought to go, if it's convenient, behind tab 17 of the authorities bundle. And it goes between the charitable regulation provisions and just before the self-build exemption 54A. So it slots in between those two.
Just a second. Right, so yes, I see. So the whole of that clip goes in there, does it?
My Lord, yes, all of it. It deals solely with social housing relief.
Yes. Yes.
I'm grateful. My Lord, the other document was the judgment in Hertsmere,
yes.
which I put in really because there's quite a neat encapsulation of the law there, which mirrors very much what's in my skeleton argument. So rather than going through the authorities bundle.
Well, should we make that tab 21 then?
Tab 21, I'm grateful.
Yeah. Right. So that's all done. Done. Done.
I'm grateful. Well, the only other matter concerns the skeleton arguments. You should have the replacement skeleton arguments and a supplementary skeleton argument from myself.
Should I? Yes. Just not sure.
Certainly got the replacement skeleton argument.
I don't have your so-called supplementary skeleton argument, is that right?
My Lord, that is... We did check a few times and...
Yeah, no, I haven't the slightest doubt that you did check, but it hasn't found its way to us.
It hasn't found its way, which is...
It's in the system somewhere.
Yes, I'm grateful. My Lord, I apologise for that. I should have brought copies along. I have actually asked for copies to be brought as I suddenly had a nagging doubt that you may not have got it.
Can we get on without it for the moment?
We can do.
While it's brought across?
We can do. The only reason that I wanted to raise it now, well, apart from the fact that I wanted your lordship to have it,
Of course.
is that I'm required to ask permission to rely on that.
Yes.
Now, without your lordship having it,
It's a difficult thing to do.
yes.
Yeah. Well, if you can make progress without it for the moment, then when it's here physically, I mean, because I don't think, well, I haven't the electronic means of seeing it at the moment. If you could arrange for it to be printed and produced,
I have. It's on its
then
way.
we can come to its admissibility, or its being admitted when it arrives.
I'm grateful, my lord. I can. There's no difficulty. I'm grateful. Well, my lord, then I'm grateful for the indication that your lordships are familiar with the authorities and also the legislation. In terms of the issue before the court, it's a relatively narrow one. It's simply whether or not a self-built dwelling that is first granted planning permission pursuant to Section 73 of the Town and Country Planning Act is disqualified or ineligible for the self-build Community Infrastructure Levy exemption pursuant to Regulations 54A and B of the CIL Regulations 2010 as amended. My lord, that is the issue in my submission before the court.
Yeah.
Section 73A concerns the grant of permission for development that has either been entirely carried out prior to obtaining planning permission or part carried out prior to obtaining planning permission. So it's generally known as a retrospective planning permission.
Yeah.
My lord, the appellant's case, in a nutshell, is that applying the approach to statutory interpretation established in judicial authority, properly construed within the context of the whole statutory scheme within which they are contained, the provisions of the CIL Regulations 54A and B do apply to permissions granted under Section 73A, and properly construed, they are neither ineligible nor disqualified. And my lord, I seek to make those submissions, applying the case law and applying what is said in various cases, but encapsulated in the Rosendale case and also in the Heronsley case, is to apply an unblinkered approach to analysis of the facts and avoiding tunnel vision in respect of both the interpretation and application. My lord, the structure of my submissions I proposed to do in this way. I was going to deal with the structure of the CIL legislation, and I am aware that your lordships have familiarised yourself with the legislation, but there are a few areas that I want to go through. I'll try to do it speedily, and if I'm taking too long, you'll let me know.
We'll say yes.
So what I was going to do is go through the the CIL legislation, which would be the Planning Act 2008, and the CIL regs that we have in the authorities bundle. I was then going to consider the law and the approach to interpretation, and then I was going to apply the facts to the interpretation that I have arrived at.
Yeah.
My lord, if I can then start by going through the Planning Act 2008, and we have that in the authorities bundle.
Yeah.
And that, the Act itself is right at the start. It's in tab 2.
Yes.
My lord, if we could start then with 205, which is a levy itself. And the levy itself came about through the Planning Act 2008. That's the first time the Community Infrastructure Levy was contemplated, and its overall purpose was to seek to fund infrastructure through a simplified process as compared to the existing process, which is through Section 106 agreements. They still exist, but the idea was for local authorities to adopt this levy and to then use it to fund infrastructure without having to go through the 106 agreement process in relation to so many other types of infrastructure. Some authorities have adopted it, some haven't. Hertsmere, the respondent here, has. But also, 205 talks about the levy itself, and it makes it clear there in subsection 2 that the overall purpose of CIL is to ensure that the costs incurred in supporting the development of an area can be funded wholly or partly by owners or developers of land in a way that does not make the development of the area unviable. That was the purpose of the levy. Moving then to 208, the liability itself. This makes clear that where the liability to CIL would arise in respect of proposed development, in accordance with the provision made by a charging authority, a person may assume liability to pay the levy. So this is where we first hear about the assumption of liability. And then at 2, it makes the Act states that an assumption of liability may be made before development commences, and must be made in accordance with any CIL regulations about the procedure for assuming liability.
Yes.
The other point just to note at this stage is subsection 3, which makes it clear that liability, although you assume it at the time you assume it, you only become liable when development actually commences. So you can assume liability, but if you never commence your development, you're not liable.
Yes.
And then subsection 4 just talks about the various provisions that need to be made in accordance with the regulations. 6 is relevant. It just makes the point that the amount is calculated from the time when permission is first granted. That's when the amount is calculated.
Yes.
And 7, the Planning Act empowered regulations to make provision for liability for CIL to arise where development which requires planning permission is commenced without it, and subsection 6 is subject to this subsection. So the overarching Act, the 2008 Act, already contemplated issues relating to development that doesn't have planning permission, and left it to the regulations to deal with that.
Yeah. Yes.
Section 209 over the page deals with the interpretation of key terms, and here I would ask your lordships to note subsection 1 describing development, which means anything done by way of or for the purpose of the creation of a new building, or anything done in respect of an existing building. And just at this stage, I just ask your lordships to note that that includes any development that does not have planning permission or may have subsequently acquired retrospective permission. It doesn't caveat what development is. It's anything done for the creation of a building. Subsection 3 makes the point that the regulations need to include provision to determine when development is treated as commencing, and we'll come to that in the regs.
Yes.
Section 210 deals with charities. This was the only exemption that was specifically mandated through the Planning Act. The rest came through the regulations later. So charities were always required to be provided for through an exemption. And 1 and 2 set out what needs to happen and what powers the regulations have to provide that exemption, and sets out the arrangements for an exemption. 3 is important in that it says that the regulations that are made may provide that an exemption or reduction does not apply if specific conditions are satisfied. So there is the power there to say that in certain cases the exemption will not be available. And when we go to the regulations, we'll see that the regulations do that. They do make provision, and they do provide conditions where the development is ineligible or disqualified. And it'll be part of my submissions in due course that there is no such condition or ineligibility in relation to retrospective permissions, but there is for other things.
So just, I may be being slow, what's the relevance of provisions for charities in the present?
So the relevance for charities, when we come down to the actual regulations, is that for charities, the 2008 Act provided for a specific exemption, and also stated that the regulations may make provision for circumstances or conditions where the exemption doesn't apply.
Right, so are you holding this up in contradistinction to other provision?
Not well, slightly, but not until we get to the regulations, my lord, themselves.
Right.
There is a slight difference there.
Yeah. All right.
My lord, 11 and 12 just deal with the amount and the need for a charging schedule and the examination of it. 215 just deals with the need to have an appeals process. I don't need to deal with that in any depth. 216 is just the application of the monies has to go to infrastructure. 218 just deals with enforcement. But just to be clear, that enforcement here is enforcement of the CIL regulations and payment of the CIL. It's not anything to do with planning enforcement.
No. Yeah.
2019 deals with
219.
219, forgive me,
Yep.
just deals with issues relating to compensation and so forth. Again, due to enforcement action, but still enforcement action.
Yeah.
220 just sets out again all the various regulations and what they may include, and it sets out all the various provisions that can be included. And then, my lord, I do again ask you just to note 220 little 3 over the page. And this provides the power for the regulations to make provision for the procedure to be followed in respect of an exemption from CIL or reduction of CIL, and in particular whether any conditions are satisfied and whether or not there is a need to notify parties about the exemption. So again, this provides that power to set out conditions for any exemption, and that's then done through the regulations.
Yes.
222, again the Umbrella Act, little 1, A, B and C, says that the CIL regulations are able to make provision that applies generally or only to specific cases, circumstances or areas, and different provision for different cases, circumstances or areas.
Yes.
So it gives that power in the regulations to specify where there's something is to be treated differently. 223, little 2. Three and 4 again set out the powers that are granted in relation to the CIL regulations, in relation to planning or development, and also guidance as to how a power relating to planning or development is to be exercised. So guidance can be given by the Secretary of State, and that has to be had regard to.
Yes.
And similarly, provision can be made or guidance can be given for if there's a necessity or expediency in the Secretary of State's view for complementing the main purpose of CIL regulations, enhancing the effectiveness or increase of CIL regulations, preventing agreements, undertakings or other transactions being used to circumvent CIL regulations. And just on that point, the Secretary of State has not given any guidance in relation to retrospective permissions.
Right.
This would have been the time to have done so through this power. There is no guidance whatsoever.
Yes.
Well, then that's a quick canter, but I'll now go on to the regulations, if that's all right.
That's fine.
Behind tab 17.
Yes.
My lord, starting then with the interpretation section, chargeable development, which is just under B, is said to have the meaning given in Regulation 9. And we'll come to Regulation 9, but that's just something we need to be aware of. Over the page is the clawback period. And your lordships will see that this clawback period applies to all the exemptions. Residential annexes, social housing relief, and self-building. Not charity here. Charitable, they have that has its own provisions. But, so this clawback. Now this clawback is in circumstances where the development that's obtained the exemption ceases to qualify. And there are specific circumstances set out in the regulations where any of this type of development, residential annexes, social housing, or self-build, cease to qualify. They no longer, for example, if social housing is no longer used for social housing, it's sold on. Similarly with the self-build, if it starts being rented out, this is all set out clearly what the disqualification triggers are.
Yeah.
There is no similar trigger in relation to retrospective emissions, but I'll come to that in detail. But this provides for that clawback specifically.
Yeah. All right.
My lord, over the page, planning permission, there's the definition of planning permission.
Yeah. Yes.
My lord, then further down, mention of relevant purpose. The next two are just relief, which is to do with extensions and exemptions for self-built housing, charitable relief, social housing. Relief for exceptional circumstances doesn't concern us here.
No, but that includes the relevant exemption.
It does. It's within the relevant exemption, but there's no issue of exceptional circumstances in this case.
Yeah.
That's a separate provision that one is entitled to rely on if a local authority has made that provision available.
Yeah, no, I was simply noticing that the definition of relief includes an exemption for self-built housing.
Yes.
Yeah.
Yes. Indeed.
And then there's a definition of self-built housing.
Yes, my lord, which is below, which says it must be construed in accordance with Regulation 54A.
Yeah.
And the same provision below for social housing relief, that's Regulation 49 and 49A, which are the ones I put in. Little 4 just deals with references to commencement of development, which is significant in the context of the CIL Regulations, is to be construed in accordance with Regulation 7.
Yes.
And then D, assumption of liability, are references to assumption of liability made in accordance with Regulation 31. The point that I just want to draw out here is that in terms of commencement and in terms of assumption of liability, the process is set out in Regulation 7 and 31. There isn't any other route that needs to be gone down in order to make sure that either of these two issues are addressed appropriately. So commencement is properly defined with reference to Regulation 7 and the provisions there. An assumption of liability is to be made in accordance with Regulation 31. That is it. There's no need to go outside of those two provisions. Regulation 5, which sets out the meaning of planning permission, I would just draw attention to the fact that little a includes Section 73A permissions, which are retrospective permissions. The only planning permission that's not caught by these regulations is planning permission that's granted for a limited period, the temporary permission.
Just a second. You're in Regulation 5.
5. So it's 5A defines what is planning permission.
Yeah.
And then little 2, subpara 2, excludes limited or time-limited permissions.
As they used to be called, I think, temporary permission.
Temporary permissions. I think they really still are.
Are they? Yeah.
At least I still call them that.
Right. So that's the meaning of planning permission.
My lord, yes. And the only point is it includes Section 70, Section 73, which is when you apply to develop without compliance with a condition, for example, or you want to make a change to the planning permission. And just one point to note here, which becomes important, is that a Section 73 permission, although it's just an amendment to the earlier permission, in terms of the planning legislation, it results in an entirely new planning permission.
Yeah.
So you have two permissions, or three, however many you apply for.
Yeah.
Section 73A is the retrospective permission.
Yes.
Regulation 6. Sets out works that are not development. And then over the page is Regulation 7, which is the commencement of development. And this is relevant, I say, in the context of the availability of this exemption, is that ordinarily commencement of development is to be treated in accordance with 7 subsection 2, which is when any material operation begins to be carried out on the land. That's when it would ordinarily commence. But Section 7(5) makes it clear that for development for which planning permission is granted under Section 73A or 1771 of the Town and Country Planning Act, which is the permission granted on appeal against an enforcement notice. So it's underground A when the Secretary of State determines the grant of permission. So it makes provision there for enforcement and provides in both cases that if permission is granted under in either of those situations, it is to be treated as commencing on the day of the planning permission. So it holds up a deeming date.
Yeah, and that doesn't require any qualification in Regulation 7(2).
No.
Oh, yeah, well, sorry, it does actually, because 3 makes provision. I think that's how it's done.
My lord, yes.
Yeah. So 2 is modified by 5 through 3.
My lord, that's right. It provides a special provision for
Yeah.
permission that is granted retrospectively. Now, it could have provided for a different date. It could have treated that development as having already commenced regardless of when planning permission is granted. But it does provide that saving that it's treated as not having commenced by the legislation until permission is granted. So it puts it in a position where it's treated as not having commenced until that date.
Yeah.
And if permission's never granted, or the development is never regularised, then it doesn't come within the CIL regulations.
No, I mean under the operation of the, if you like, the parent planning regime, if development is carried out without the benefit of planning permission which it requires, and then an application is made under section 73A and that either isn't determined or is refused, then enforcement action can be taken against the development that's been carried out without planning permission. So that's how the planning regime operates.
That's right.
Yeah, yes, and there can be enforcement action, and that can result in a planning permission being, a deemed planning permission being granted under ground A, hence the provision in sub-regulation 5B.
2177A.
Yeah.
That's right. So what I would say about that is that it's quite clear that in terms of development, that is retrospectively granted, whether it's through 73A on the motion of a party, or whether it's through enforcement action.
Yeah.
It is accounted for here in Regulation 7, and provision made for it to be deemed not to have started until the day that permission is granted.
Yes.
My Lord, 8 is simply saying when permission first permits development is when permission is granted, as one might expect. Regulation 9, then, is one upon which some weight is placed
Yeah.
by the respondents.
Mm-hmm.
This is the meaning of chargeable development, and it says at little 1, the chargeable development is the development for which permission is granted.
Yes, can we just pause on that?
Yes.
The present tense is used, planning permission is granted. Does that mean, do you contend, the same as planning permission has been granted?
No, my Lord, and that's actually in my supplementary skeleton, which is
is it? Oh.
that very point, which has been, I don't know if it's worth passing that up just now.
You have it now, do
I
you?
have it.
Is its admission controversial?
I haven't heard anything from anyone. It's been with them for about 10 days, I think.
My Lord, sorry. In terms of allowing the supplementary skeleton argument in,
Yeah.
no.
Right, that's what I was asking, I think.
Pass it up.
Is that right, Miss Lambert? Yeah.
Thank you.
Thank you very much. Right, I think the best thing is, it's what, 2 pages in effect.
short.
If you'd like to sit down while we just read our way through that.
I'm grateful.
Thank you.
My lord, I'm grateful.
Just pause for a second.
Sorry, I'm just on the last paragraph. Yes, thank you.
Thank you very much. So the point that I've just raised with you, you deal with at paragraph 11 of your, and 12 of your supplementary skeleton.
My lord, yes, precisely.
I'm not sure you say there, though, perhaps you do, I'm not quite sure, what the words used actually mean.
I've said at 12.
Yes.
Equally apt for permission granted retrospectively or at a later date as for one that exists at the time of the assumption.
So it would, that, just to add to that, to clarify completely what it means, that would make it equivalent to is to be. It is means has been or is to be.
My lord, yes.
Is that how you construe
Yes, I
it
think that's fair
in
enough.
context?
Yes. I mean,
I don't want to,
No.
impose that
No.
instruction on you if it's not what you're asking us to conclude.
No, my lord, it is another way of saying what I've said
So-
at 12.
So, at least provisionally, let's understand then that your construction of is granted connotes that is means has been or is to be in that context. I think that's what you're submitting.
My lord, yes. I mean, what I'm saying is that it's equally apt for either. So it certainly can't, it shouldn't be construed, I say, as something that has been, because there's no reason why the legislation wouldn't have used that construction. Perfectly straightforward English.
Right.
And it would have been the easiest thing in the world to say that.
It would have been the easiest thing in the world, you submit, to say has been if they really meant only has been. And that is can, in context at least, convey both a grant already in place or a grant yet to be in place.
Yes, and my lord, the key point is in context. That is the point. In context with everything else here, that is what I say it should be interpreted as.
Yeah, we understand that.
I'm grateful.
Yes, just pause for a second. I'm going to put your supplementary skeleton together with your principal skeleton. Yes.
And again, my lord, I mean, no doubt you've read this. The reason that I submit is entirely appropriate is because liability doesn't arise until you actually commence development in any case. So there isn't a need for it to be permission that has been granted. There's a point made, I think, by either the Council or the Secretary of State that that's when liability needs to be crystallised. But that's not the case. It's actually crystallised when you commence. That's the only time it actually crystallises.
Yep. All right.
My lord, then there's, it is just worth looking at little subpara 6 here.
Yes.
Because some points are made by my learned friend, I think Mr. Honey, or Secretary, for the Secretary of State, in relation to Section 73 permissions and some saving provisions later on for subsequent Section 73 permissions. I just make the point here, which I did touch upon earlier. There's a specific reason why Section 73 permissions are addressed here, and that's for the reason that I mentioned earlier, that a Section 73 permission, although for the layperson is simply an amendment, it actually results in a brand new permission. This could mean then, if this provision wasn't there, 6 and following, little 6 and 9 there, you could be liable on the basis of both permissions, because you may have commenced your earlier permission and then got a Section 73 permission and commenced that, and you would be liable because liability crystallises when you commence. And this is to address that mischief.
Does it say first commenced anywhere?
It does, I think, say first commenced. somewhere.
Most recently commenced.
Yes, most recently commenced or
Yeah.
recommenced. So in other words, you may have got your permission, started it, then decided that you want to change the windows or you want to not comply with some condition. You get that permission under Section 73 and you carry on working on the basis of that permission. You would then be liable twice. That's why it was necessary to bring in.
Yeah.
I think this is an amendment that was made, in fact.
Yes, I mean, is the practical point really that you're liable, but only once,
Yes.
and only in respect of the development that you actually ultimately build?
Yes,
Yeah.
that's right. So the reference to Section 73 here and later must be understood in its proper context. This is not giving Section 73 some status over and above Section 73A, or Section 73A couldn't be mentioned, or should have been mentioned. It's completely irrelevant here. Section 73 is the one that grants the subsequent permissions, and it was necessary to have this amendment. As I say, I think it is an amendment.
Oh, yeah.
Yes, it was an amendment, in fact, because otherwise people were being liable twice, which can't be right.
Right. Right.
Well, the assumption of liability, which is Regulation 31, and this seems to be the real bone of contention, I think, between parties, because what is said is that by the Secretary of State and by the Council, the first respondent, that you can't assume liability until permission is granted. That is their case.
Yeah.
The appellant's case is that you can assume liability before the grant of permission, and there is nothing in the regulations, read in context, or the Act, that prevents or in any way removes that ability. And again, I say read in context because in the context also of the Act. Now, what is said in Regulation 31, and we know from the interpretation section that assumption of liability has to be undertaken in accordance with Regulation 31. What it says here is that if somebody wants to assume liability, they have to submit an assumption of liability notice to the collecting authority. And then it says, in order to do that, it must be submitted in writing on a form published by the Secretary of State, or a form substantially to the same effect, and include the particulars specified or referred to in the form.
Yes.
And little 8, subpara 8, says an assumption of liability notice is valid if it complies with the requirements of para 2.
Yes, that's the validity of the notice itself.
Yes.
It doesn't mean, does it, that the assumption, the underlying purported assumption is necessarily lawful. It means that the notice has complied with the requirements of sub-regulation 2,
Yes.
or paragraph 2 rather.
Yes, but that's all that is required, is what I would submit.
Yes, when you're
Yes.
submitting a notice, yes.
Yes.
You see the distinction between the substantive and the procedural here. If I'm right in
Yes.
construing it that way.
Yes.
You can comply with the notice requirements under 2,
Yes.
but the assumption of liability may be misconceived.
Well, my lord, but for subpara 4.
But for subparagraph
Yes.
4.
Otherwise, I see your point. But for subpara 4, which
Right.
says a person is deemed to have assumed liability on the day on which the collecting authority receives a valid assumption of liability.
Yes, it might be contended that that is simply to clarify the appropriate point in time at which liability is deemed to have been assumed. If it's not validly assumed, it's not validly assumed might be the contention against that submission.
Yes, I can see that one could take the argument to that point.
Yeah.
But if one looks at Regulation 31, which is the whole need to assume liability.
Yes.
And the purpose of that is somebody who's assuming liability to pay, obviously, still. And then, in order for someone to provide a valid notice, so it's got to be a valid, proper notice, I would submit that 4 takes it to the point that then you are deemed to have properly assumed liability. Because if you you've sent in your valid assumption of liability notice, and it is deemed to be, you've deemed to have assumed liability, what are the steps that would render it invalid in the context of Regulation 31, I would ask. What other steps could there be? If you've done what's in 2, it's deemed valid, and 4 tells you that you are deemed to have assumed liability on the very day that a valid assumption notice is received, which is valid if it complies with 2 and A and B.
Yeah, and I just wonder about this. If the whole thing is, as it were, a complete fiction,
Yes.
The effect of paragraph 4 cannot be to create, as it were, from nothing, or from that fiction, this critical step in the whole sequence of steps, which leads ultimately to, you say, to the exemption. That's all I'm testing with you.
Yes, I mean, I suppose it might be helpful to go to the form to see what has to be filled in. Because you have to have a material interest.
It might. By all means, we can do that. If you
I wouldn't have gone to
like
it now, but we can do it.
Yes, if that suits the stream of argument.
Yes. Well, I'll come back to it, but I can come.
Well, can I come back to it later? Yeah.
I can go to it very briefly now, just to deal, I hope, with the point. It's in the supplementary bundle board.
Right.
It's tab 8.
Or page would be 32.
32, my lord, yes.
Yeah. That's the 1st of February 2020, Form 2,
Yeah.
Assumption of Liability Form. Yeah.
So, my lord, this is the assumption of liability form that was filled in. And this is the form published by the Secretary of State. So the person is assuming liability for the development. And it can be, I'm not sure if there's any restriction on who it can be, who is choosing to assume liability. I mean, it would be a bit crazy, I think, to assume liability for such a tax, unless there was some basis for doing so.
It's a personal liability.
It's a personal liability.
Yeah.
It's a charge on the property. So I do understand the point that Your Lordship's making, but I'm, in my submission, I'm not sure that it's a point that actually goes to the issues here.
Okay, fine.
Why would you assume liability?
No, fine. I mean, I was simply testing it. It may not be a contentious point.
Yes, I'm not sure it actually does go, at least in my submission, to any real interpretation point.
Yeah, I mean, I think the main argument on the other side, as I've perceived it to be, is about I'll put it in very crude terms, the unavailability of the necessary statutory gap,
Yes.
or legislative
Yes.
gap. The construction offered on the other side is that, properly construed, these provisions just close that gap to nothing.
That's right. That's what they say.
Yeah, and that's really the essential thrust, I think. If I got that wrong, they'll put me right.
No, I think that is what is being said.
Yeah.
On the other side, I say, my lord, that is a self-created issue. The regulations themselves don't create the collapsing of that gap, as it's put.
Yeah, I mean, that's really the contentious
Yes, that's
area
the
in the whole case.
That contention, though, arises because it's said that assumption of liability can't take place before the grant of permission. That's why that is an important issue.
Yeah.
Because it is because of that, when you look at 54A, 54B, you just,
Do you want to go there now?
I think just for this point.
Yes, fine, okay. 54B then,
B.
yeah. Yeah.
54B.
Yes.
54B sets out the conditions for obtaining the exemption in the first place, the procedure. And you've got little 2 sets out what has to happen, and it's little Roman 2 that talks about having had to assume liability. And little Roman, sorry, subsection 3 is why there is this issue about the gap, according to the respondents. Subject to 3A, a claim under this regulation will lapse where the chargeable development to which it relates has commenced before the collecting authority has notified the claimant of the decision on the claim. So what is said against the appellant is that you can't assume liability until you have permission. And once you have permission, the development's commenced, and therefore you can never get your exemption, having regard to little 3, because the claim lapses if you commence. So it's a sort of chicken and egg is what is being said here. Does that make sense, my lord?
I think so. Just say it again.
I'll say it again.
No, yeah.
I'll say it again. So, my lord, if you look at 54B, the procedure requires at subsection 2 that the claim has to be made. So there's sort of 3 parts really to this. The claim has to be made by a person who intends to build or commission the building of a new dwelling, intends to occupy as a main residence. That's one condition.
Yeah.
Second is that they have assumed liability to pay CIL in respect of the new dwelling.
Yes.
Right. Now, this is where it ties in with this permission point.
Yeah.
If you can only assume liability when you have permission to obtain this exemption, then you can never get the exemption because of little 3. Because the moment that you get your permission, under Regulation 7.5, my lord, if you remember I pointed out that saving for the retrospectives which says it commences at the time you get your permission.
Yes. There'll be an automatic lapsing.
It's over. According to this is how the Secretary of State and the Council have interpreted this.
Yeah.
That you can never get it because
there's an instantaneous and automatic, inevitable statutory lapsing.
That's right. But that all depends on this very key question is whether you can assume liability before you get planning permission.
So the key question on this analysis is whether you can validly assume liability before planning permission is granted.
That's right, my lord. And that's my hypothesis, is that you can. There is nothing that stops you in the structure of this Act from assuming liability before you get planning permission. And if I'm right about that, then there's no problem with this gap issue.
And that's actually the crystallisation of the whole case.
My lord, I would say so. I mean, there are some other sort of peripheral points.
Well, well, it is in the sense that if you're right in that submission, you submit that the other side has nowhere else to go.
My lord, yes, because then what they should be doing is determining our claim. If I'm right about that, then Section 54A and B require the claim to be granted in all other circumstances, as long as it's self-billed and all of those other considerations.
Yeah, so, matters that are a fact that are not in dispute.
They're not in dispute. No one's claiming we're not living in the house and the like. So in that situation, having regard to Section 54A and B, the claim would be valid and had to be granted. And there would be no reason why, and it has to be granted, my lord, as soon as practicable, which is 54B little 4. So it has to be speedily granted.
Yeah.
And so what I would say is, having received that claim, valid claim, I would say valid assumption of liability, then they should have granted that exemption and then granted the permission. And then there's no problem with this gap, because we wouldn't have commenced anything before having been given a decision on the claim. So we wouldn't fall foul of 54B. We only fall foul because the respondents insist that you can't assume liability until you've got permission.
Going back to what you said just now about the sequence, they should have granted
Yes.
But they should have granted under sub-regulation or paragraph 4, regulation 54B, the exemption,
Yes. Must grant.
before they granted planning permission. The corollary of that would be that if they did grant planning permission, they shut out the exemption.
That's right, my lord.
And what is there to prevent them doing that?
Yes. Well, my lord, that absolutely, my lord's absolutely at the heart of it here, because on the facts of this case, what the first respondent will say is that they granted the permission and, that the claim lapsed because they hadn't notified us about the exemption. But there's nothing to stop anyone, but I would submit that on a proper construction of this legislation, it would be quite perverse for an authority to do that when it knows that an application for an exemption is being made.
Well, that would be a different claim, wouldn't it?
Well, my lord, no, because for this reason, what is being said is that what is being said in the respondent's notice by the first respondent is resurrecting a point that was taken below, but was then accepted by all parties to be as such, because the first respondent always proceeded on the basis that they could not grant the claim. Always. Back from, I think it's September 2020, whenever all this sad story began, they've always written to the appellant and said that you can't avail of this. So there's never been a question that they would have treated this application in some different way.
No, I think I'm on a slightly different point. And if it's a bad point, then tell me.
No.
But you've shown us this intricately, meticulously constructed statutory scheme. You've taken us through it. The question that lurks then might be this, mightn't it? Why is it that the legislature did not provide explicitly and clearly for that which you've contended ought to have happened in this case, i.e. that
Yes, I understand.
an exemption application, effectively, an application for the exemption, must be dealt with in these circumstances prior to and only prior to the determination of the application for planning permission.
My lord, I understand.
And so the other side might submit, I don't know if it does or not, that it is curious, to say the least, that this point wasn't attended to in the legislation.
My lord, I understand. Apologies, I was going off on a different point.
No. Well, I mean, I think it's a related point. I mean, but actually, that seems perhaps to be the central point, given the contentious argument in the present case.
My lord, the answer in my submission to that is that the legislation didn't need to do that.
Right.
The reason it didn't need to do that is because if one looks at the whole construct of this Act and the regulations, it is intricate, but perhaps not the best drafted set of regulations. That's in the industry, at least, that's quite often commented upon.
Right.
Now, that being so, it's necessary for the court to interpret what is actually meant by these regulations.
Of course.
And that's what your lordships are doing. In that context, one has to look at what is the reality of the situation, realistically. The reality of the situation here is that there is nothing in these regulations or the Act, anywhere, and I have a few more provisions to go through
Yes, yes.
in due course. There is nothing in any of these provisions that deal with the central point. The central point is the ineligibility or conditionality of the permission being retrospective. That's the central point that legislation should have dealt with, not these rather these points that arise much further down the line, or could arise much further down the line. The central issue is, why didn't the legislation mention this rather important matter that although retrospective permission can be granted and subject to CIL, actually you can't benefit from any exemptions. In my submission, that's the point that the
Yes,
legislation...
and I think the response of the other side to that is that assuredly the legislation did not do that because it did not need to do so. Intricately constructed as it was, the proper construction in context of all these provisions bearing on that question is that the legislation operates to shut the gap to nothing. That is the central contention on the other side. And the answer to your submission, I apprehend, given on the other side, is that the legislation could indeed have said what you've just said it doesn't say, but it didn't need to do so, because the proper construction of the provisions leads you to the same place.
Yeah.
I think is the answer.
Yeah, well, my lord, that can be said, and that obviously is an argument that can be made.
Yeah.
But what I would submit is that having regard to the correct approach to interpretation of legislation, while one can probably come to many different interpretations of all of these provisions, that interpretation is too stretched because you need to first deal with the ineligibility of retrospective permission. The reason for that, my lord, is if one looks at 54A, for example, just the
Yeah.
first words.
Yeah.
It's at 54A1. A person is eligible for an exemption from liability to pay CIL in respect of chargeable development or part of a chargeable development if it comprises self-built housing or
Yeah.
self-built communal development.
Yes.
And then it sets out those conditions. And then it becomes clear from B that if you comply with all of this, you must benefit from the exemption. But having regard to the interpretation authority, judicial authority, it says here a person is eligible. There is no caveat here that they are not eligible for an exemption if the development is given permission retrospectively. There were ample places for this to be said. It could have been said in the conditions. For example, 54B, the claim must be made by a person who intends to build, etc., etc. It could have said anywhere that these exemptions are not eligible if they are granted retrospectively. In my submission, that is the bigger question rather than...
Yeah, it's curious perhaps, I don't know, maybe not. But the way it's constructed in these two provisions is 54A provides the exemption for self-built housing, and you submit that the primary provision in paragraph 1 of that regulation is unqualified,
Yes.
i.e. is eligible if it comprises self-built housing. And 54B is headed exemption for self-built housing procedure. So it is ostensibly a procedural provision. And it starts by saying a person who wishes to benefit from the exemption. So the notion might be, I've got the exemption, but I can't benefit from it until and unless I do these things. So it's a curiosity, if that construction is right, that the exemption is available and due, if you like, but it can only be benefited from if certain things are done, or in certain circumstances as described in 54B. So that's the way that the legislation has been conceived.
Yes.
But the other side might say, well, it comes to the same thing ultimately. Even if it's the proper construction is that you've got the exemption, but you can't avail yourself of it for the following reasons, ... It comes to the same thing as not having the exemption in the first place. I don't know whether that's quite how they put it, or if I've understood it properly.
Yes. Well, I think that the only issue here, from at least as I've understood it from the respondents, is that they say that when you work through the requirements of 54B, you can't. I think the bottom line really is that they say you can't assume liability until you have your permission. That's what it comes down to. Going back to your point, Mother, which led to this discussion, which is what is there to stop the council from issuing the permission before determining the claim? That was.
Yes, it's as if to say the exemption is there, but forever out of reach. Out of reach because there is no means of getting at it in consequence of paragraph 3 of Regulation 54B.
Yes, but only if you can't assume liability.
Yes. I mean that
Yes.
that of course.
Well, I accept that.
I'm just looking at the way that it works, but I mean the primary contest is the one that you've identified, I think, isn't it? Which is whether or not, as you've described it, the key question is whether or not one can validly assume liability before planning permission is granted.
Yes.
If one can, you submitted, there is no problem with the gap issue. That's what you said. So that's the issue.
Yes. And my lord, you did raise that supplementary point, which was what's to stop the local authority issuing the permission.
That's right.
Before you get your exemption.
Yes, I did raise that.
And what I said about that was why there's no need to work that into the Act, is because if the council did do that, if they did that, it would be perverse to do that. And that would be a separate claim altogether that one would bring, as one often does against perverse.
Well, I don't know whether it comes within the scope of the way you've pleaded the present claim.
No, I'm not pleading. I'm not pleading.
No.
perverse.
I mean, the case is set up as a contest on statutory interpretation. The practical question being exemption available or not.
Yes.
And that's.
So I was just answering your question.
No, sure, yes. Oh, that's.
It's not part of my case.
No,
Needed.
I've got that.
Yes.
I was simply testing the point.
Yes.
Or trying to. Yeah.
I think I mean what I was trying to do is say that it doesn't need to have those words because you could bring a separate claim.
I've got that. Yes.
Yeah, as one does, my lord, on many cases.
No, I do understand that.
Yeah. So I don't think that needs to be. That's not the point here. It doesn't need to have those words. But my lord, I think
all of that was by way of a major diversion
Yes.
from what you were submitting.
Yes.
You were on Regulation 31.
I was, my lord. I was on this.
Just to remind you of where we were. But maybe what's followed has largely covered much of the important territory here.
Yes, quite a bit of it, but not quite all. My lord, just working through the assumption of liability provision, because it is important, this one. There's a number of points in terms of the interpretation. Looking at the various steps, and the question really of whether you need to have permission first, because that, as I say, that's the central point here. What you've got to do is to obviously submit that notice, and then the key part is 2, which has got to be in writing on a form published by the Secretary of State, and include the particulars specified or referred to in that form. And if that is the case, then it's valid, and you've assumed liability. And as I say, if it is right, if I'm right that you can do that before the grant of permission, then there is no problem with the legislation and being interpreted in the way that I say, because you can have a gap. There's no problem there. There wasn't much of a gap in this case, but what I submit is that doesn't really matter on this case because the local authority never accepted that they could grant this exemption from the beginning. So that's not in dispute. But my lord, here the question here is, why is it said that you need to have planning permission? Why is it said? There are various angles taken by the respondents But I do submit, my lord, that they are all a mythical construct, really, that isn't borne out by the reality of these regulations or the Act either. One of the points taken is the meaning of chargeable development. And my lord, that's 31(1) says, a person who wishes to assume liability to pay CIL in respect of a chargeable development. And what the respondents say, going back to that regulation 9, is that means it's a chargeable development that has been granted permission. And my lord, we've been over that, the word is. So I say that that doesn't help them.
Yeah.
So one major part of their argument relies on their interpretation of what that means. Yeah. The second point that they say is that you can't set the amount of the assumption. Well, when you've assumed liability, actually that comes. Oh, that's more to do with Section 54A. I'll come to that later.
Mm.
Then they say that. I think this is a rather a bad point, but it is a point taken against me by both the respondents. In 2, it said that an assumption of liability notice must be submitted in writing on a form published by the Secretary of State and include the particulars specified or referred to in the form. And what's being said by both respondents is that, my lord, if you do have that form open still.
Yes.
Page 32.
Mm-hmm.
What they say is that, look at this form. It says description of development, and it asks for planning permission reference.
Yeah.
Right. So they say that you can't fill that form up unless you have the planning permission reference.
Yeah.
Now, in reality and practice, the planning application number reference and the permission reference are the same, and they were in this case as well.
Yeah.
So I say this is neither here nor there, particularly, my lord, where it says at 2A that it's a form published by the Secretary of State or a form to substantially the same effect. So I say that whether it's the application number or the permission number is substantially to the same effect. So I don't think that really helps them. That's not a knockout point in my submission.
Well, the way in which a form is drafted, even as a pro forma, cannot of itself dictate statutory interpretation.
No, and there's another reason for that too, because if one remembers here from the legislation, it's a form published by the Secretary of State himself. So it's not so if he's got it wrong there, that can't help.
This is on the planning portal, this form.
Yes.
So it's a standard form.
Seems to be a standard.
So wherever I am in the country and I'm making an application such as this, I'll find this. I'll be using this form.
That's what I've understood.
Yeah.
But as your lordship says, that can't be.
No, that would be tail wagging dog.
Well, it would, and I mean, it's quite clear from the regs here that it's the form published by the Secretary of State. So if they've done that. We're
really focused on the provisions of the legislation.
But what they have argued, the respondents, is that because of that form and that requirement for the permission number, that we can't fill the form up, and therefore we can't deal with 2B. That's what they say.
Yeah.
Which I don't think is with respect a good point, but for the reasons we've just discussed. But that's their other point on that. Look at that slide.
Shall we put away the form now?
My lord, yes.
Yeah.
I think we can put that away. Well, just on an aside, not that it's determinative either, but it's probably just worth noting that the respondent council accepted the assumption of notice form and sent us the required acknowledgement, which is 31 subpara 5. So they sent that anyway, which indicates that they regarded it at least as a valid assumption
Yes,
liability.
well, I suppose. Sorry, second cliche coming. What's sauce for the goose is sauce for the gander.
Exactly.
You know,
I accept that.
that was an administrative step that they took. It doesn't transform that which was done, if it wasn't lawful, into something that was lawful,
I accept that.
or vice versa.
I accept that. It's just an aside point.
Yeah, right, got it.
But yes, quite right.
Yeah.
So, my lord, that so that just working through then Regulation 1, which is and the arguments against me. Those are the main arguments against me in terms of why it's said that you can't grant, you can't assume liability until you've got permission. And I say that that doesn't stand up. It just doesn't stand up. You can, because you can do exactly what is required by Regulation 31. You can complete the form. You can include the particulars. And there is nothing in any part of these regulations or act read in context that says you can't assume liability before you have permission.
Right.
And not only is there nothing, the Secretary of State in guidance that authorities are required to have regard to tells you to do exactly that. If you look, my lord, at the last page of this authorities bundle.
You mean in tab 20?
Tab 20, just
Yeah.
the very last page.
Yeah. Yeah.
My lord, this is the PPG, the Planning Practice Guidance,
Yeah.
issued by the Secretary of State.
Mm-hmm.
And this is what, so quite apart from telling anyone that they can't assume liability or that retrospective permissions are not eligible, if my lord looks at bullet 3, in all cases where CIL is payable in relation to the development, the collecting authority will expect the developer, landowner, or another interested party to assume liability for the levy by submitting an assumption of liability form. It may speed up the process of issuing a liability notice if this form is submitted before planning permission is granted. Now, I mean, that's statutory guidance, which has never been amended or changed or qualified.
Right. Right.
So, well, what I say then is that really on a fair, realistic, contextual reading of Regulation 31, there is absolutely nothing in there or anywhere to say that you must first have planning permission. And it matters not if you assume liability. So contrary to what the first respondent says, that, oh, well, we have all these different departments, and why would anybody be receiving these assumption of liability forms before permission is granted? Well, first of all, the first respondent did just that. They did accept it. But secondly, it matters not, because liability does not actually crystallise until you commence the development. So the planning permission is not the problem here. It's not the issue here. And the Secretary of State is telling us that we should in any case be speeding up the process and sending it off earlier, before permission is granted. That's entirely consistent with the statutory scheme, I submit. They're right to do so.
That's in all cases where CIL is payable.
My lord, yes, in all cases.
In all cases where CIL is payable. Is CIL payable in respect of self-build?
Yes, unless you get an exemption. So it is payable, yes.
That goes back to the point my lord was asking you, is eligible for an exemption, but can only benefit from it if you go through various procedural hoops.
That's right, it's 54B in particular.
Yes.
But there is no impediment to 54B, which we can go to, other than if you can't assume liability. And the only way you can't assume liability, according to the respondents, is if you have to get permission first. Because if you have to get permission first, then you lose the exemption because you have commenced development by virtue of getting the permission. But if you don't have to get permission before assuming liability, then there's no impediment to 54B, then you're not excluded. Then you're not in Hotel California.
You can check out, but you can never leave.
Exactly. You're not there. And I think it's probably worth just going back to 54, my lord, just to make that point, especially for my lord, Lord Justice Edis. If you just look at the provisions of 54B, which obviously are the key ones, so once you're eligible, just to make sure you're not in Hotel California, you just work through this. 54B, if you want to benefit from this, you submit your claim. And then these are the requirements of the claim, made by a person who intends to build or commission the building and has assumed liability to pay CIL. And then, importantly, B, subject to 3A, which doesn't apply here really. Subject to 3A, it says, be received by the collecting authority before commencement of the chargeable development. And then you've got to fill the form up again, which you can fill up here because it says application reference, not planning permission in this case. Include the particular specified or referred to, and again, if you're sharing liability, then you share it. Now, working through that, on my hypothesis, you submit the claim by a person who intends to commission the building of a new dwelling. Now, it's said against me that if it's retrospective, you can't be intending to build anything. Again, I say that that's not consistent with the context of the Act because there is already a deemed commencement due to Regulation 7.5, which says that when it's retrospective, you're only deemed to commence when permission is granted. So if you're deemed to commence when permission is granted, there is nothing wrong with the words intends to build. That is consistent with the approach of the legislation, which says you don't commence. So you may well have commenced and built the whole thing, but according to the Act, you haven't, because you only commence at the time permission is granted. That's Regulation 7.5. And that was a special saving for retrospective permissions. So intends to build, I say, it does not, on a proper construction, cause any difficulty. Intends to occupy as a sole or main residence for the duration of the clawback period. Well, that's obviously, I think it's 7 years or 3 years. You have to occupy it. And then little 2, which has assumed liability, whether or not they've also assumed liability for other development. And all this must be received by the authority before commencement of the chargeable development. Now, if you can assume liability, as I say, Regulation 31 clearly permits, and we are advised to do by the Secretary of State's own guidance, then there is no reason why little 2 can't be complied with. So in my interpretation, little 1 and little 2 can be complied with. The reason they can be complied with are the points that I just made, that having regard to Regulation 7.5, commencement doesn't occur till you have permission, which means you are intending to build. There's nothing in those words that kicks you out. Has assumed liability Yes, we have, because we don't have to wait for permission to do that. And in fact, the Secretary of State tells us not to. So we can meet little b, which is that the council or the collecting authority, whoever they are, will receive all of that before commencement of the chargeable development. So before permission is granted, all that can be done. And we did that. The appellant did that. They sent all of this documentation, plus the assumption of liability form, prior to the grant of permission.
Yes.
So far, there is no impediment to us complying with the procedure 2A, Roman 1, Roman 2, or B. There is also no impediment to complying with C or D. We've filled up those forms and we've completed the particulars. There's no issue taken about that. And in that case, the form only asks for an application reference. It doesn't ask for the permission anyway. So we can comply with all of that. There is then the lapsing provision, which is 54B3. And it says here that the claim, your claim, will lapse if the chargeable development is commenced before the collecting authority has notified the claimant of its decision on the claim. So if you start your development before receiving the claim, the decision on the claim.
Commenced means commenced, not commenced or deemed to be commenced.
Commenced is in accordance with Regulation 7. So all of commencement is in accordance with Regulation 7.
Is that right?
Yes, my lord. If you recall the interpretation section, it said commencement must be interpreted in accordance with Regulation 7. I think it was Regulation 2 that says this. Go back to that.
Yeah. Reference 2 says, sorry, do you mean 2 or 1, 2? Sorry, 2, you mean, it's the interpretation, yeah, sorry, 2,
yeah.
2,
it's 2,
sub,
oh yes, my lord, it's in fact, it's 4, so it's
4.
little sub 4, which is, so it's
References to commencement of development must be construed in accordance with Regulation 7. Yeah.
And then if one goes to 7,
Treated as commencing.
yes, treated as commencing.
So we are to understand commenced in 54B3 as meaning actually commencing or treated as being treated as commencing. Is that right? Is that right?
Sorry, let me just check that.
Yeah.
It has effect for determining when it's to be treated as commencing. Yes, so for all development that applies to, not just to retrospective.
Yes, but to apply it to Section 73A
Yes,
permissions.
yes.
I'm just pausing on that because it may be quite an important point.
Yes, so my lord, the point was that...
Well, the question is what does commenced actually mean in 54B3?
Yes, so it says commencement of... Just looking back at this regulation, which is where we have to go to for commencement. Treated as commencing. So little 2 is development is to be treated as commencing when a material operation. So that's for normal planning permissions, any planning permission.
Yeah.
And then for 4, it says treated as commencing that's to do with limited permissions. And then 5.
Well, if it didn't mean actually or treated as commencing, then there would be a lacuna, wouldn't there? Because there wouldn't be a provision that is apt to cover Section 73A.
That's right, and that's there at 5. And in fact, they're all to be treated as commencing. That word is that phrase is consistent with all of the.
Yeah. Maybe it's just. Maybe I've just set a hair running. That's the third cliche.
No, I think if I've understood your point, my lord, is that, and I hope I'm addressing it.
And what I'm saying is, sorry to interrupt you, but what I'm saying is there has to be a provision that is apt to deal with Section 73A. It may be that the drafter believed that had been dealt with by the provision in Regulation 24A, so that the reference to commencement, which is commenced in 54B3, is to be taken as meaning actually commenced or treated as having commenced. And
I think it has to be that, as you were saying.
That covers Section 73A.
I think, my lord, that has to be right because it says references to commencement. So I suppose that covers treated as commenced.
Well, references to commencement must include the use of the verb is commenced.
Yeah.
I think.
Yes. But I think that I'm not sure if it's really a point, only because, my lord, if you look at Regulation 7, it talks about all the development being treated as commencing. So that's sort of the use of the word treat doesn't seem to have any great meaning because it treats development that hasn't commenced as being treated as commencing when any material operation begins.
Yeah, I think that is. I think reading all these provisions together probably supports the construction of commenced in 54B3 as meaning commenced or treated as commenced.
I think so.
And that would then cover Section 73A.
That's right. That's what I would submit. It seems they seem to all be treated the same way, and it's brought within the umbrella of Regulation 7, and that's covered then, as you say, my lord, or will be covered. I would submit anyway.
So does 54B3 mean that in an ordinary planning permission case, if somebody gets planning permission and then jumps the gun and starts the work before the decision's been made, then
They've lost it.
they've lost
That's
it.
right, yes, my lord.
But if you've got retrospective planning permission, this is, you forgive my very crude lay description of it, this is simply validating what's already happening or happening. So the development has commenced.
Yes, but that's, my lord, that's precisely the point. It hasn't because of Regulation 7.5. My lord, that's precisely the point. This is why I say that retrospective permissions are not excluded from 54B. If my lord goes back to Regulation 7...
Sorry, it says the claim lapses where the chargeable development is commenced before notification of the decision on the claim.
Yes.
So if retrospective planning permission is given before the decision on the claim has been notified, doesn't the claim lapse?
Yes, then it would lapse. That's right. Yes.
Right.
Yes.
Right, so...
And what was the factual position here?
The factual position here was that the factual position here is that the claim was submitted and the council maintained all along, from the very outset, that they would not entertain the application because they believed that a retrospective permission could not benefit from the exemption. So they never gave any sort of, they didn't consider it.
Yeah, but what my lord is driving at, perhaps, I think, is that, in fact, what took place here was that development did commence, or was to be treated as having commenced when planning permission was granted, and the claim thus lapsed.
That's right.
And so what?
Well, this was addressed below as well, but the point that I think was accepted below by the learned judge and generally was that because had the council, and that's why this point's important about the assumption of liability, had the council correctly understood that we were entitled to the exemption, they wouldn't have issued the permission. That's the point.
Yeah, well, is the position then that in the circumstances of this case, there's nothing to be done about it?
Well, there is. I think we've had the relief does ask for. I mean, this is a point that we've grappled with.
That, I mean, even, how does it work then if your submissions are right, but the facts are what they were?
It's locating the claim form.
Of course, yeah. You want to go into the core bundle, I think?
Yes, it is the core bundle.
The claim form.
I'm not quite sure what I've done with the core bundle.
Tab 13, page 180.
Got it.
What is being judicially reviewed is the decision to refuse or fail to grant the claim, and the relief
Yes. So we're asking that the decision to refuse the claim for self-billed exemption was unlawful and should be quashed. So really asking for the court to put the appellant into the position that they should have been in had the council actually determined the claim correctly. Because the claim was received, we say validly. The council says you could never make a claim in the first place, and so it didn't determine it, issued the permission.
So, yeah, I mean, of course, relief is a discretionary matter, but the aim of the claim is to restore the appellants to the position they would have been in before planning permission was granted.
Right. Yes, that's right. Well, before planning permission was granted, but also bearing in mind, when I just go through some of the emails, bearing in mind the council's position from whenever it was, it's always been, even on their documentation.
But there's no challenge to the planning permission, of course.
No.
The planning permission's been granted.
Oh, yeah.
It would be an odd thing to do for the appellant to challenge the grant of planning permission that they'd secured.
Yes.
So the planning permission remains in place.
Yes.
You see, maybe there's a fundamental question here, and perhaps I'm misunderstanding it, which is what purpose can the proceedings actually achieve?
Well, the issue of the planning permission was considered, but it would be odd because it would leave the development that had taken place.
It would render the development without planning permission.
Exactly. So that was not.
So but in fact there is no challenge to the planning permission. The planning permission stays in place. And to follow my Lord's question, with this question, why is it then that even on your submissions there isn't in fact under the provisions a lapse of the claim?
My Lord, because what the appellant is asking the court to do is to put it back in the position that it should have been in, and to make an order quashing the wrongful decision of the council, which was never to determine this.
But they couldn't determine an application that had lapsed.
No, my Lord, but I think the basis of it is that they accept, have always accepted anyway, that they would never determine the application. They didn't consider one could be made. That was their stance. So in that situation, the planning permission was issued. What we're asking is for the court to go back to that original approach of the council, relying on 54B and A, which says that the exemption must be granted if the procedure is followed. So it's a mandatory grant. So preventing the prejudice that's occurred to the appellant through the council's wrong approach to the regulations. That's really what we're asking for the appellant. I mean, from a wider perspective, this has got implications for all self-builders going forward, and also for social housing relief. So it is certainly going to be of value, whatever the court says on this point.
Well, no doubt. But what we're exploring, what I'm exploring at the moment, is the question as to whether the court, if the court accepted your submissions, whether the court can contrive a situation in which, as you would contend, the right decision is made.
Yes.
Anyway, we will need to reflect on that, perhaps.
Yes. It is something that I have reflected on. And I came to the conclusion that the court could put the appellant back in the position that they should have been in.
Even if the planning permission is not
Even if the planning, because of the unlawful approach of the council earlier and their misunderstanding of the regulations, if that were accepted. So I think they could. Below, that wasn't an issue.
No, it doesn't. It doesn't, I think, feature in Mrs. Justice Thornton's judgment. No,
it doesn't, and it didn't, from my recollection, particularly trouble the court for the reasons I think that I'm saying.
Right.
But right. I suppose there would still. I mean, there must be some remedy, I suppose, is what. If the appellant's submissions are correct, if they're correct, then there must be a remedy for the appellant. I think that's the point here, because the only reason that the permission was granted was because of the misunderstanding of the regulations.
Well, yeah, but the fact is that a planning permission was granted, which you say should not have been granted before the claim. Yeah. Claim had been before the exemption claim had been determined.
Yes. Well, I suppose the other alternative, not the best, but the other alternative would be if my interpretation is correct, and the court were to say that, in terms of future enforcement of that liability, the appellant would be able to have some remedy, I think, in terms of the reasonableness of enforcing that by the council.
Oh, I see.
Because, of course, this is only the start of the process. This is the liability. It goes much further. There's a demand notice.
No, I think I understand that.
So I think that would still be.
Well, we'll see what the council says about it.
Yes.
I'm sorry to sort of carry on with this.
No.
I hope you'll forgive my saying that it's not a terribly sophisticated approach to say to us there must be something we can do.
Yes.
The chronology on page 89 describes some well, actually going back to page 88, just at the bottom, discussions by email and so forth between the appellant's wife and her cousin
Yes.
and some planning officers.
Yes.
And we've apparently got copies of the various toings and froings. But then the relevant form, eventually signed, is submitted to the council, which they acknowledge. And then 2 days later, the planning permission.
Yes.
And as a matter of fact, there's no decision. I mean, what the council have been saying in correspondence, can you categorise that as a decision?
I think one could, yes. That would be the decision, because they weren't going to grant it, and they subsequently made the point that they haven't offered it. So that is a decision not to grant. I think that can be categorised as a decision.
And that's the only way
Yeah.
forward for you,
Yeah,
isn't it?
I think that's right. I mean, I
It's not that again, I'm very sorry to interrupt.
No.
I didn't think it's exactly how you were, how it was put in the claim in the first place.
yes, well,
But anyway,
not to disassociate myself with the claim at all, but I didn't draft the claim.
no, well, I follow that. All
I
right.
fully adopt the claim, but just
Yeah.
to make that
Sorry,
I think you are as it were saddled with the claim at this stage.
Yes, absolutely, fully.
Yeah.
I fully accept that. I
Anyway,
think.
I'm sorry, you
Yes.
carry on with something else.
Yes. No, my lord, I accept the point. I also accept the point that my lord made about it not being a terribly sophisticated way to deal with it. I think the difficulty for, the very real difficulty for the appellant here is that, and what is a little different to perhaps a contractual or commercial issue, is that the council is a public authority and is required to act reasonably and fairly in the public interest. And in this particular case, if the appellant was correct and had been trying to get this exemption for quite some time, and the cousin, I think it's Miss Chesterton, wrote just before this decision was issued saying, please can you determine this application because I know permission is going to be granted soon. There is a duty on the council to act reasonably. They cannot act as a public authority in a perverse fashion or in an unfair fashion. The only reason that unfairness has come about, issuing the permission, is because of the unlawfulness, we say, of their approach. It's not that the appellant here has done something to bring about the commencement of that permission, of the development. They could have done nothing more than they did, which was to plead with the council, please issue your decision. Now, ultimately, the court may decide that's not the correct interpretation, but if the court did decide it was the correct interpretation, there is nothing that the appellant could have done in those circumstances where the council was maintaining their own approach to the retrospective permission. So it's a very unfortunate situation, and that's why I put it that way, that there has to be a remedy, given that it's a public authority that has acted in that way. And this isn't a case where the council, the appellant could have done anything more than it did in those letters. And I do say that if the council had understood the regulations correctly, they would have not unilaterally issued that permission, because as your lordships know, you can always agree to extend time. And they did do. Earlier on, they had extended time to issue the permission. So there was no obligation on them to issue that permission as they did. The only reason they did was because they misunderstood the regulations, and I'm sure a local authority acting reasonably would not have done that.
Yes. Anyway, I don't want to take us round in circles, but the fact remains that the challenge is not to the planning permission they actually granted. The challenge is to the decision or non-decision on the claimed exemption. Anyway, I think we've covered that ground quite thoroughly.
I think so.
Just pausing for a second to take stock. How are you getting on now, do you think?
I think, my lord, let me just pick up my...
You want to make absolutely sure that you've had the chance to make your argument in full. But I sense that perhaps we have largely covered the ground you wanted to cover.
Yes, I think I largely have. There's just a, I think, there's just some points on the provisions, I think, that I did want to cover.
Yes.
In general, which are the sort of more the broader points about the availability of the relief and whether, in the proper context of interpretation, it can be said that retrospective permission is excluded. And that's really to do with, I mean, just take up the social housing relief provisions that I handed in this morning, which I think they were put behind tab 17.
Yes, thank you. That's Regulation 49.
49.
Yeah.
And the point that I just wanted to make about this is that this regulation, which is to do with social housing, also is subject to the issue of submitting or assuming liability. And you get that at Regulation 51.
Yeah.
So again, in terms of the procedure for this relief, you have to assume liability. Now, the argument that you cannot assume liability or you cannot benefit from this exemption unless permission is granted would equally apply to this relief. And this relief is to do with social housing or affordable housing. So there's a public policy benefit. And 49 subsection 3 onwards sets out various conditions before this type of dwelling is eligible. And all I would say here is that looking at these provisions, in circumstances where various conditions are set out, there's no reason why, if retrospective permission for social housing was to be excluded, that wouldn't have been set out as a condition as well, that it cannot be a retrospective permission. Because there can't be any sensible reason, I suppose, why social housing, which the government wants to encourage, should be excluded because it might have knocked a wall down, which requires retrospective permission. On the respondent's interpretation, it would not be eligible. So looking at the purpose, there is no reasonable purpose why these regulations would intend to exclude that sort of development. And it's probably just useful to go into the supplementary bundle.
Yes.
My lord, it's page 147. I have it behind tab 20.
Yes.
And this is the explanatory memorandum for the introduction of the social housing exemption and the self-build exemption. you could turn to para 7.2.
Yeah.
So the purpose of these regulations was said to be to improve the administration of the levy and to make its application fairer and more transparent. And 7.13 at 149. Sets out what the purpose of these reliefs and exemptions are. And it's clear from 7.13 to 15 that the idea was to support the government's objectives for affordable housing. And at 7.15 to make it easier for people to build or extend their own homes. And that's why there's the exemption. The purpose is to promote this sort of development. And it is inconsistent and in fact frustrates the purpose to interpret the regulations in the way that the respondents do. It's necessary to look at what the purpose is in terms of interpreting the legislation. It can't be it can't be ignored. And far from making it easier for people to self-build, I mean this is a case in point where it's done the exact opposite. Far from being transparent or making it easier, it's actually made it much harder if the interpretation that the respondents impose is the correct one. And that is the opposite of what the purpose of these exemptions is. My Lord, if we could also just go to the other document that I handed up, which came in after 129.
Yeah.
And it's paragraph 4.38.
So this is the CIL consultation.
Yes.
Date.
July, I think it was 2009.
Yeah.
So, my Lord, just before this is a part of the consultation documentation that the Secretary of State has referred to. So the bit before. That deals with some references to where there's no planning permission and what needs to happen and so forth in that context. But the extract that the Secretary of State refers to stops at 4.199. What this document does is just picks that up and goes a bit further and deals with exemptions specifically. The Secretary of State praised that document in aid to explain the approach to enforcement. But the same document actually deals specifically with exemptions as well, which I would submit is more relevant.
So where should we look?
If you look at 4.38, so this was prior, so this is when the regulations themselves were being enacted back in, so prior to 2010, 2009, before self-build exemption and before social housing. At that time, they were only talking about the principle of exemption and asking various questions, and talking about the charity exemption. But when one looks again at the purpose of these regulations, 4.38 makes it clear that the government wants to avoid complexity and distortions and ensure fairness across the whole regime. And the bullet points should not create scope for challenge, be difficult to apply, or create a loophole because it's not clear what it applies to. Should be fair, not create undue distortions, etc. So, bearing in mind this, if it's an aid to interpretation, the interpretation advanced by the respondents does the opposite. It's very difficult for somebody to read those regulations and do anything other than adduce that they are able to benefit from the self-build exemption because they are building a dwelling for their own use and they've completed an assumption of liability form and provided it. Had the government genuinely or had Parliament genuinely wanted to advance the approach that the respondents advanced, then to meet that purpose, it would have had to say somewhere, none of these exemptions apply to retrospective permissions. That would have been the obvious thing to do, rather than this rather intricate maze of inferences which don't lead to that answer, unless you go down the road that the respondents do. But a layperson would not do that. And the whole point of the self-build is so that the ordinary person can build their own homes. That's what the government says, or the legislation is intended to do.
Clues in the title, I suppose, isn't it?
It is. It is. Absolutely. So,
Yeah, I suppose it might be the retort to that, to say that that Section 73A applies, of course, to everyone in its effects, both self-builders and developers, major and minor developers. The planning system does not differentiate.
yes.
Within its principal provisions.
Yes, although, my Lord, when the 2019 regulations, the amendments were made, it's expressly said in the explanatory memorandum, my Lord, that is to do with an earlier provision in these regulations that said that if you don't submit a commencement notice, you lose your whole exemption.
Yeah.
And the government, and the explanatory memorandum does say that that's removed because that burden falls, that misunderstanding or not being familiar with the regulations, even though it was expressly in the regulations, falls disproportionately on lay people. So that's actually, in fact, I'm not sure if it's in the bundle, but it's certainly referred to in the court judgment below that quote as to why. There is a recognition by the government that these CIL regulations are not supposed to be complex in their interpretation.
Yes.
And I feel that the overriding point is that the approach by the respondents is anything other than straightforward. And if one applies the principles of interpretation, which I'll very briefly go to, this would be a maze for anybody to understand, that they have to interpret is in a particular way when it's is chargeable development. They have to work through these regulations before they start building their house or applying, which can't be right. You embark on a project because you think you're exempt from CIL. No ordinary house builder would expect to be paying £118,000 tax when they understand there's an exemption, and that's obviously what happens. That isn't consistent with advancing the purpose. That's frustrating the purpose, and that's contrary to the case of filed. I did check the pronunciation of that.
Yeah, filed. Right. Yes.
Well, then just very briefly on the case law, because I know that your lordships dealt with that, has familiarised yourself with that.
Yes, we
Very
are
briefly.
familiar with it. Yes.
Well, in fact, the case law I would submit is summarised almost completely in the judgment of Hertsmere, which is paragraph 62, if you have that to hand.
Right. So that is the first instance judgment of Mrs. Justice Lane.
Yes, indeed.
And paragraph
62.
Yeah.
It's also in my skeleton argument, so I'll just go through it very briefly. Paragraph 62 onwards, and this just sets out the key principles, if I can just touch on them. And the first is that a citizen must be taxed in clear terms, so the liability should be clearly defined. I say this is the opposite, because on the face of it, when you read the Act and the legislation, you would think that you aren't liable because you can have an exemption if you follow the procedure. And there's nothing in the procedure that makes it clear that you are supposedly not able to with retrospective permission. And that's particularly the case in relation to where there are financial consequences. That's paragraph 64 and it's the reference to the IDT card services case. The leading case is the Rosendale case, which really summarises all the other cases and makes it clear that there should be a purposive construction. And over the page, under paragraph 10, it says the central importance in interpreting any legislation is to identify its purpose.
Yeah.
Underneath that, there's a reference to Bloomsbury International. In matters of statutory construction, the statutory purpose and the general scheme by which it is to be put into effect are of central importance.
Yeah.
And then 13 below, there's a reference to the Barclays case. And it's the part in quotes, which is to give a purposive construction in order to determine the nature of the transaction to which it was intended to apply, and then decide whether the actual transaction, which may involve considering the overall effect of a number of elements, whether it answers the statutory description. And my lord, here I would say that the transaction to which it's intended to apply is self-build dwellings or social housing, but we're dealing obviously with self-build here. And then in the Arrowtown case, it's this paragraph which says the driving principle in the Ramsey line is to involve a general rule of statutory construction and an unblinkered approach is whether, to the analysis of the facts, the ultimate question is that whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically. And well, that's where I say this is exactly on point with our case. Viewed realistically, unblinkered, it is obvious that the legislation was intended to apply to self-build. And that is what this property is. There is no purpose in eliminating permissions simply because part of it was obtained part retrospectively, the demolition part in this case. Paragraph 16, avoid tunnel vision. I would submit that the interpretation of the respondents is actually applying a tunnel vision, looking at it without looking at the purpose, without looking at the overall context of the Act and legislation, but looking at this rather intricate series of possible meanings that eventually lead to the outcome that is being suggested. Then there's a filed case at 66, which talks about making sure that you arrive at an interpretation that serves rather than frustrates. And I'd say that the appellant's interpretation serves rather than frustrates. Paragraph 70 simply makes the point that my lord, your lordship already made about the limits of the Secretary of State's approach to things, which is that the guidance is limited. It can be persuasive, but well, this isn't even guidance, this is just the form.
Yeah.
Yes. And then my lord, paragraph 72, just the bottom. What is impermissible is to treat the wishes and desires of the government about the scope of the statutory language as reflecting the will of Parliament. And that's important here because quite a lot of the arguments made really concern how the collecting authority or the Secretary of State have organised the collection and administration of CIL. That's not the same as how the legislation is to be interpreted.
Yes.
Now, the remainder of that judgment talks about some of the extrinsic material and so forth. I don't think we need to go into that.
So, in sum, you are submitting to us that paragraphs 62 to 72 of Mrs. Justice Lang's judgment in that case represent an accurate and up-to-date encapsulation of the relevant principles, enshrined as they are in authority at the highest level in this jurisdiction?
My Lord, yes. I mean, I would, I think, first rely on my skeleton argument, where I put case law there. But I think that broadly that is reflected in.
Broadly speaking, I think the passages you've referred to in these various cases are those referred to by the judge.
Yes.
Here.
I would say so. So, well, that's there's only one further point on this which I'll deal with if I need to in reply, but just very briefly, it's covered in the supplementary skeleton. The Secretary of State says the purpose of this approach is to prevent unlawful development. That's what the Secretary of State says, and I would submit that can't be correct for the reasons that I've said in my skeleton argument. Enforcement in the planning context is not punitive; it is discretionary, and it would be extraordinary for this act to be used in this surreptitious way to somehow punish people who haven't first got planning permission. And that too in circumstances where the Planning Act entirely permits regularising permissions, both through the enforcement process and through Section 73A. Section 174, as your lordships will be aware, makes it very clear that you can appeal and ask for permission to be regularised. There's no penalty at that stage. The only penalty is if further enforcement measures are taken. So that I submit cannot be the purpose. If that's the only purpose, then that's wrong in my submission. But I think those are all the points that I would make.
Thank you very much. Thank you very much, Ms. Sheikh. Yes, Ms. Lambert.
The Council's submission is that whether on a straightforward or a purposive interpretation of the legislation, the appellant could not claim or benefit from the self-billed exemption. And furthermore, even if he could, as a matter of fact, he claimed too late. And my Lord, that's the point that's raised in the respondent's notice.
Yeah.
And so my submissions are structured to deal firstly with the meaning of the relevant regulations in context, secondly to address the statutory interpretation, and then thirdly to deal with the matter raised in the respondent's notice, the matters of fact. First of all, the meaning of the relevant regulations, my Lord. In my submission, there are a number of regulations which, when read and interpreted together, bar the self-billed exemption to this category of planning permission. And my submissions here are under three main subheadings. Firstly, chargeable development, then eligibility for an exemption, and then whether the procedural requirements for a claim for exemption were complied with. This starting then with chargeable development. And Malone Friend is right, this is central to the Council's position, that the grant of planning permission is the key event for considering and granting exemptions. And that's because it's only on the grant of the planning permission that chargeable development exists. And then the sequence of events that the CIL regulations mandate can then flow from that. So I know there's already been significant time taken looking at the regulations in detail, but if we could turn up certain of the regulations for the Council submission. So first of all, Regulation 9 is on page 557 of the authorities bundle.
Well, I don't think we have, at least I don't have, a paginated bundle.
So sorry. Behind tab 17.
Yeah. And you're looking at Regulation 9.
Regulation
I think we can find that.
And Regulation 9.1, where there is a difference in interpretation, that the chargeable development is the development for which planning permission is granted.
Yes.
Now, my lord, as to whether this means has been granted or not,
Yeah.
in my submission, it plainly does mean has been granted. And there is support for this interpretation within the regulations, which I'll come to. Before I get there, once chargeable development exists, the sequence of events that follow are calculating liability, notifying of the liability, and then collecting the levy. And the liability, Milena Friend is right, crystallises on commencement of development. But the local authority is required to send out a liability notice setting out the liability, and that must be issued as soon as practical after the day on which planning permission first permits development. And so, my lord, in my submission, the need to correctly calculate liability can only take place after planning permission is granted. And the notice must accurately set out that liability. If I can take your lordships to Regulation 40.
Yeah.
Regulation 41.
Yes.
States that the collecting authority must calculate the amount of CIL payable, chargeable amount, in respect of a chargeable development in accordance with this regulation. I'm so sorry, I was looking at...
We're looking
I think
at-
that's Wales,
We're
isn't
looking
it?
at the Welsh provisions.
I think it's in
Sorry.
accordance with the provisions of Schedule 1.
Provisions of Schedule 1, I'm so sorry.
Yeah.
And Schedule 1, we don't have the contents, but Schedule 1 has the title, Calculation of Chargeable Amount, etc.
Do we not have Schedule 1?
We do have Schedule 1 at the back.
Yeah,
We
is
have
The very
Schedule-
last page of this tab, I think.
All
isn't
right,
it?
yes. Just a second. Yes.
Schedule 1, Para 1.
Ah. Mhm. We've got a number of Schedule 1 provisions. Yeah.
Yes, so on this page we see that the Schedule 1 title is Calculation of Chargeable Amount, and Para 1 we have Chargeable Amount Standard Cases. So just looking at this for a moment, this sets out the calculation of the chargeable amount in standard cases, and in order to calculate the chargeable amount, the chargeable development must exist. If my lords look at 1.6, this sets out the formula for the value of A, the value of A being part of the formula set out at 1.4 for the calculation for the amount of CIL chargeable. para 1.6 sets out the value of A must be calculated by applying the following formula. And then on the next page, we see where G is the gross internal area of the chargeable development. And so if the calculation relies on the gross internal area of the chargeable development is tied to the planning permission. The planning permission must exist so that the chargeable development exists and so that the formula for calculation can be applied.
Well, yeah. I mean, that depends on that understanding of this provision. Depends on the proposition that planning permission is necessary for the chargeable development areas crystallise. I think. So to have your G value, you must have your submission is to have the G value and indeed the GR value. You must have planning permission in place.
It cannot be a planning permission to be granted because the planning permission may be granted for something different. In order for certainty, and part of the purpose of the CIL regs is certainty, in order for certainty one must know what the planning permission was for.
Yeah. The fundamental submission you make, and that lies behind this, presumably, is that CIL is a charge on development for which planning permission is granted. It has to, because it's a tax, it has to be based on a precise calculation.
Yes.
And the precise calculation is impossible until you know what planning permission has been granted for.
Exactly.
There may be conditions on the planning permission that create different circumstances which would need to be drawn into this calculation.
Yes.
The gross internal area may be specified and differentiated as between different uses, for example.
Yes. And my lord, at tab 20, just moving away from the CIL regs briefly, at tab 20 is some relevant extracts from the National Planning Practice Guidance. And on page, sorry, my lords don't have page numbers, but turning through a few pages, your lordships will find a flow chart for the standard cases.
Yeah. Right, so we're now, the document we're in here is the PPG. And this is the 1st of September 2019 version of it. Yeah, sorry, yes, the flowchart.
And here we have, again, a formula which comes from Schedule 1, Para 1, 4, where A equals the deemed net area chargeable at rate R, and IP being the index figure for the calendar year in which planning permission was granted. And so in my submission again, the formula here relies on having a planning permission having been granted, so that the calendar year is known, so that the relevant index figure can be applied.
Yes, the drafter has then gone on to use the future tense in the same flowchart at 10.2. Anything turn on that?
in the area in which the chargeable development will be situated.
One might expect it is situated.
Yes. Yes. But in my submission, that doesn't affect the application of the formula in terms of the year for the index figure being certain.
Yeah, I
and
mean,
also the timeline shows again.
The submission, I think, really is that because this is a tax, there must be an exactitude about what the tax is being levied on.
Yes.
And that exactitude is established by a grant of planning permission. That exists, not one that might exist if the proposal is determined in a particular way.
Yes, my lord, I was just trying to take your lordships to various documents which support that. But yes, that is the point, and it's because of that in my submission the respondent's interpretation of Regulation 9 is the correct one, and that chargeable development is the development for which planning permission has already been granted.
Right.
And so the council does not grant exemptions or calculate relief unless it knows that there is a liability and it knows the amount of liability, and it cannot calculate the liability unless it knows what the chargeable development is.
Yeah.
Well, that brings me to Regulation 31.
Right. Yes.
Regulation 31(3). The liability is to pay an amount of CIL equal to the chargeable amount less the amount of any relief granted in respect of chargeable development. Shows again relief and liability are linked. And chargeable development and chargeable amount are linked. And so this comes back to the same point. Planning permission is required in order to assess the chargeable development, to then calculate the chargeable amount, and then calculate the relief. And that is the basis for the council's submission that there could never have been a valid claim for an exemption because there was no chargeable development when the claim was made. And as soon as there was chargeable development on the date that the retrospective planning permission was granted, by virtue of Regulation 7(5) and Regulation 54(b)(3), any claim would lapse. Well, that brings me to Regulation 54(a)(1). I see the time.
Oh, yes. Right. Yeah. Well, we shall come to that then after a short adjournment. We'll resume at 2 o'clock. Just before we rise now, obviously there's some overlap between your submissions and Mr. Honey's. We would not expect normally to be listening to the same submissions made twice. So I dare say there would have been some discussion about how long you require, Ms Lambert, and how long, Mr Honey, you would require in the light of that. If that conversation still needs to happen, then perhaps it should over the adjournment. But how long do you expect to be broadly?
Broadly, I thought I would be about an hour.
An hour, yes.
And so I hope to be able to keep to that.
Mr Honey?
I would expect, my lord, about 3/4 how to deal with matters, and I would certainly have, so far as it were, been going through crossing bits out of my notes. Right. I will inevitably have to ask your lordships to look at the regulations again, etc. But I'll do what I can to limit any repetition.
All right, understood. Thank you very much. 2 o'clock then.
All right.